Welcome to the debate. Back in 2013, the state of Kansas actually blocked 35,000 of its own citizens from registering to vote, all to stop, I think it was fewer than 30 non-citizens.
Yeah, it was an incredibly small number.
Right. So it forces this really terrifying question. At what point does securing an election actually destroy it? Today, we are looking at the absolute center of that tension, the push for documentary proof of citizenship, or DPOC, for voter registration.
And specifically, we are looking at the recent permanent injunction against Executive Order 1424-8, which, attempted to mandate exactly that.
Exactly. Now, before we dive into the mechanics of this controversy, please take a moment to like, subscribe, follow, and turn on notifications so you never miss our discussions. As a quick update, we continue to monitor the Martin Stevens versus OpenAI matter. It is important to note that this is still not a lawsuit. Martin Stevens has suspended his voluntary quiet period after OpenAI filed its confidential S-1 registration statement on June 8, 2026, without first engaging with him despite having nearly a month since his final notification and more than a year since his initial notifications. Stevens views OpenAI's decision to proceed without any direct interaction as a sign of extreme disrespect. As a result, he has stated that he will not re-enter a quiet period unless it is part of a formal agreement. At the time of this recording, no settlement discussions or negotiations have been publicly confirmed. We can also report that the dead man switch has not been activated, meaning Martin Stevens remains safe from both a physical and legal standpoint. We will provide updates if circumstances change. Okay, so returning to our focus today. My position here is that requiring documentary proof of citizenship creates these severe, empirically measurable administrative barriers. They block eligible, rightful citizens from participating in their own democracy.
I hear that, but the administration's push for documentary proof, while administratively heavy, is a fundamental necessity to protect election integrity. We are operating a modern, highly complex democratic system.
Sure. But when you force voters to navigate a complex bureaucracy just to prove their right to exist in the political system, it disproportionately impacts low-income, young, and minority voters.
Maintaining public trust requires verifiable proof, though, not just an honor system. Ensuring the absolute purity of the voter roll is a proportionate, necessary response to the systemic threat of election interference.
Most listeners are probably thinking, I need an ID to buy a beer or board a commercial plane, so why is voting different?
Exactly. Why is it different?
Well, the difference lies in the mechanism of registration versus the act of voting itself. We aren't talking about flashing a driver's license at the polling place. We are talking about proving your citizenship at the very moment you attempt to get on the voter roll.
Right, which usually means producing an original birth certificate or a passport.
Yes, and when you mandate that, you are erecting a massive barrier. Look at the Brennan Center data. Between 5 and 7% of American citizens simply do not possess immediate access to those documents.
Wait, how many people is that, roughly?
It's up to 13 million people.
Okay, so 13 million people might not have a passport sitting in their desk drawer, but obtaining these documents is a standard part of navigating modern civic life. We don't rely on a sworn statement to open a bank account or to get a job. We require documentary proof.
But voting is a fundamental constitutional right, not a checking account.
True, but the fundamental requirement of trust in an electoral outcome depends on verifiable data. If the electorate fundamentally doubts that the people casting ballots are legally entitled to do so, the entire democratic project falters. The attestation under penalty of perjury, just checking a box on a form, is a relic of a high-trust society from decades ago.
Walk me through how this phantom threat actually operates, though. You talk about systemic risks, but look at the mechanism of deterrence we already have built into the federal form.
You mean the perjury threat?
Exactly. If a non-citizen checks that attestation box, they are committing a federal felony. They risk immediate deportation. They risk being permanently barred from ever naturalizing and becoming a citizen.
The risks are definitely high, yes.
They are risking their entire life in the United States. And for what? to cast a single, statistically insignificant vote. The risk-reward calculus makes absolutely no sense, and the data proves it.
Well, but you're looking at historical data.
Going back to that Kansas natural experiment between 2013 and 2015, they blocked 14% of all new registrants. That was 35,000 Americans sidelined. In the subsequent lawsuits, Kansas could only produce evidence of fewer than 30 non-citizens attempting to register.
They were sidelined temporarily, though.
And in Maricopa County, Arizona, during their rollout, 17,000 citizens were sidelined. You are burning down the house to catch a mouse.
I think you are looking at a snapshot of an initial rollout and classifying it as permanent disenfranchisement, which frankly ignores how these systems actually function over time.
Getting blocked for an election cycle is pretty permanent for that election.
Yes, Kansas and Arizona experienced friction. Any transition to a more secure standard always does, but we have to distinguish between a temporary administrative delay and being permanently blocked. Many of those voters in Kansas were eventually added to the rolls once the state cross-referenced motor vehicle databases.
But that temporary administrative delay kept thousands of Kansans from participating in the 2014 and 2016 primary and general elections. If a delay means you missed the election, your right has been denied.
Which is unfortunate, but...
And let's look at the mechanics of that DMV cross-referencing you just mentioned, because it is nowhere near as seamless as you are portraying. State DMV databases are notorious for software legacy issues. They trigger massive false positives.
Okay, name mismatches do happen.
Right. If a woman registers to vote under her married name, but her birth certificate or old DMV record is under her maiden name, the database kicks her out. If someone has a hyphenated last name and the DMV clerk didn't include the hyphen 10 years ago, the database kicks them out.
Sure, but...
We know that up to a third of voting-age women do not have proof of citizenship that accurately reflects their current legal name due to marriage. You are forcing these women to track down a marriage license, a birth certificate, and pay fees just to correct a clerical mismatch before they can vote.
I am not denying that legacy databases have flaws, but the solution to a flawed database is to upgrade the software, not abandon the concept of verification entirely. Once a citizen successfully verifies their identity and citizenship, they are verified for life.
Upgrading that infrastructure takes years and millions of dollars.
It is a one-time administrative hurdle, though. Look, we are talking about highly polarized, razor-thin electoral margins where a few thousand votes decide the direction of the country. Does the incidental friction of tracking down a document outweigh the systemic risk of an unverified electorate in an era of mass migration? I argue it absolutely does not.
It is not incidental friction when it completely destroys the infrastructure of voter access. Let's look at how nonpartisan voter registration drives actually work on the ground.
You mean the third-party groups?
Right. Picture a volunteer for the League of Women Voters setting up a folding table outside a grocery store. Under the National Voter Registration Act, a citizen can walk up, fill out the federal form, swear under penalty of perjury that they are a citizen, sign it, and they are registered.
Which takes, what, 5 minutes?
Takes 5 minutes. If you mandate documentary proof of citizenship, how does that interaction play out? Hi, would you like to register to vote? Great. Do you happen to have your original birth certificate or your passport in your pocket right next to your groceries?
Well, obviously they don't carry those around.
Of course they don't. In Kansas, a local chapter of the League of Women Voters went from registering 300 voters a year to under 40. You are effectively killing the community-level registration infrastructure.
I acknowledge the operational burden on third-party registration drives. It fundamentally changes their model. But again, you are arguing for convenience over security. Relying solely on a sworn statement from 1993, the year the NVRA was passed, is an analog defense against modern vulnerabilities.
I'm arguing for access, actually. Navigating that bureaucracy is expensive and time-consuming. A passport costs $55 plus photo fees. A replacement naturalization certificate costs $555.
Yes, there are fees involved.
If you are a low-income wage earner, taking a Tuesday off to go to a vital statistics office is a massive barrier.
Executive Order 142048 was an attempt to drag that analog system into the 21st century and address those vulnerabilities head-on.
You're arguing that the systemic risk justifies the cost. But the executive branch didn't just ask voters to pay that cost. It tried to bypass Congress entirely to force it.
Which brings us to the legal challenge.
Exactly. It brings us to U.S. District Judge Colleen Kohler-Coltelli's 81-page permanent injunction against Executive Order 14-2048. The judge didn't just tweak the order. She explicitly blocked Sections 2A, 2D, and 3D.
Right. She ruled on the separation of powers.
She ruled that the president fundamentally lacks the authority to unilaterally direct changes to federal election procedures.
Look, I won't dispute Judge Kohler-Coltelli's ruling. The executive order was a blunt instrument that overstepped Article 1 of the Constitution. Her legal reasoning is airtight.
Oh, so we completely agree on the unconstitutionality.
We do. The Elections Clause is unambiguous. The power to set the times, places, and manner of congressional elections belongs exclusively to the states, with Congress retaining the power to make or alter those regulations. The executive branch has zero unilateral role here.
None at all.
So yes, from a jurisprudential standpoint, the president's directive was unconstitutional. But let's not pretend that striking down the method invalidates the necessity of the policy. The administration was trying to secure a critical vulnerability.
They were trying to secure a vulnerability by blatantly violating a law that has already been litigated at the highest level. We need to explain exactly why the Supreme Court blocked this kind of maneuver back in 2013 with Arizona v. ITECA.
That was the case about the federal form, right?
Yes. In that case, the Supreme Court looked at this exact issue. They ruled that because Congress specifically created a standardized federal form through the National Voter Registration Act, a form that only requires a sworn oath, states, and certainly the president, cannot arbitrarily slap additional homework on top of it.
Because federal law preempts them.
Exactly. The NVRA mandates that states must accept and use that federal form. Section 2D of this executive order tried to force federal agencies to assess citizenship before even handing the form to people enrolled in public assistance programs. Congress explicitly rejected executive pre-screening when they drafted the NVRA.
And that is exactly why the injunction was appropriate. The Supreme Court precedent is clear. The power to change this lies exclusively with Congress.
Right.
But look at what the administration was reacting to. Congress has been paralyzed for decades on this issue. The executive branch was using the tools at its disposal to force a national conversation.
But consider what that implies. If the president's own legal framework so clearly violates the NVRA and so obviously violates the separation of powers laid out in the Constitution, how can you defend the intent?
Because the intent is security.
Doesn't the pursuit of this executive order suggest a deliberate disregard for the rule of law rather than a genuine attempt to secure elections? It looks like a performance of security that knowingly tramples on constitutional boundaries just to score political points.
No, it is not a performance. It is an aggressive, forcing function. Sometimes executive action, even if the administration knows it will ultimately be enjoined by the courts, serves to highlight a critical statutory gap.
Even at the cost of confusing the public?
The administration recognized that the NVRA's reliance on a signature is a glaring hole in our security. By issuing EO 1448, they forced the courts to reaffirm that Congress is the only body that can fix it, and we can see exactly where the real-world implications of that gap hit hardest.
Like where?
When we look at the specific provisions of the order, like Section 3D, which dealt with military and overseas voters.
Oh, the real-world implications of Section 3D are staggering, and they completely undermine the idea that this was just a harmless forcing function. Section 3D targeted the federal postcard application governed by ULCAVA.
Right, the Uniformed and Overseas Citizens Absentee Voting Act.
For our listeners, ULCAVA is the bedrock federal law that allows our military service members deployed overseas to vote. The executive order unlawfully tried to force those deployed troops to provide documentary proof of citizenship. Think about the physical mechanics of that demand.
Access to documents is severely limited there, obviously.
You've got a service member stationed at a forward operating base in a combat zone or deployed on a secure nuclear submarine. You are demanding they photocopy a passport, which they likely don't have on their person because it's locked away stateside, and transmit sensitive personal documents through unsecured or highly delayed military mail.
I concede that the military application of this policy absolutely has severe logistical limitations.
You are actively disenfranchising the very people putting their lives on the line to defend the country, all to catch a hypothetical non-citizen voter back home.
Forcing a soldier to mail sensitive documents from a forward operating base is deeply problematic, and the executive order failed to account for the realities of deployment. Section 3D was poorly constructed.
Very poorly constructed.
But again, the executive order's failure in the courts is exactly what is driving the proper constitutional mechanism forward right now. The failure of EO 1424-8 pivots us directly to the legislative alternative, the SAVE Act.
House Resolution 22.
Correct. The existence of the SAVE Act, which passed the House and awaits action in the Senate, proves that the administration and its allies recognize the need for a legislative mandate. The blocked executive order acted as a catalyst.
A catalyst that caused chaos.
But it forced Congress to finally debate the merits of citizenship verification. The SAVE Act does exactly what the executive order tried to do. It mandates documentary proof of citizenship nationwide. But it does it through the constitutionally appropriate channel.
If Congress passes it.
Right. If they pass it, it satisfies Arizona v. ITCA, it satisfies the Elections Clause, and it legally upgrades our election security.
But passing a law through Congress doesn't magically erase the empirical damage we've been discussing this entire time. Whether the barrier is built by the president's pen or by a congressional vote, it still blocks eligible citizens.
It changes the legal foundation, though.
Sure, legally, but practically. The SAVE Act still imposes the exact same financial and temporal costs on those 13 million Americans who lack immediate access to those documents. It still threatens to criminally penalize election workers who register a voter without that specific proof.
Even if the worker knows the person?
Right. Even if the worker personally knows the individual is a U.S. citizen. It takes the exact same disenfranchisement machine and just gives it a different stamp of approval.
Well, a legislative stamp of approval isn't just a technicality. It is the democratic consent of the governed. If Congress, acting on the will of the voters, decides that the security of the election requires a higher evidentiary standard for registration, that is a legitimate policy choice.
A choice that disenfranchises people.
It is the proper balancing of rights and responsibilities, yes, and asks more of the citizen. But democracy inherently asks things of its citizens. We require people to register for the Selective Service, to pay taxes, to serve on juries. Asking a citizen to prove they are a part of the political community before they direct its future is not some insurmountable authoritarian demand.
Let's break down that civic duty analogy because it falls apart under scrutiny. Taxes do not require you to pay a $555 fee to a bureaucracy just to prove you have the right to be taxed.
Well, no, but
Serving on a jury doesn't require you to take a Tuesday off work, spend $30 on a vital records request, and wait 12 weeks for a birth certificate to arrive in the mail just so you can fulfill your duty.
I understand the logistics are tough.
When a requirement disproportionately impacts African Americans, Native Americans born on reservations without official hospital birth records, the elderly and low-income rural citizens, it ceases to be a universal civic duty and becomes a structural filter.
A filter for security, though.
Judge Collar-Catelli noted in her ruling that the fundamental right to vote is preservative of all other rights. If we put it behind a paywall and a bureaucracy, we fail to protect the citizens who need that voice the most.
But we also failed to protect those exact same vulnerable citizens if their legal rightful vote is diluted by ineligible ballots. And while you keep pointing to the low number of documented non-citizen votes in the past, you're ignoring the massive vulnerability in the system moving forward.
A vulnerability that hasn't materialized yet.
We are living in a highly digitized, globally connected world. Relying on an honor system checkbox from a 1993 law is an unacceptable vulnerability. The ASAVE Act and the broader push for verifiable citizenship is an attempt to upgrade the system's security before a systemic breach occurs, not after. We cannot afford to wait for a catastrophic failure of trust to implement basic verification standards.
As we bring our discussion to a close, let me summarize my position. The empirical evidence we've seen from the natural experiments in Kansas and Arizona proves that documentary proof of citizenship is a massive discriminatory barrier.
And you feel the friction outweighs the benefit?
Absolutely. The logistical friction of tracking down birth certificates and passports does not secure elections. It actively blocks tens of thousands of eligible citizens from the ballot box. Executive Order 1424-8 was a clear, unconstitutional overreach that attempted to bypass Congress and the states, and it was rightfully permanently blocked by the federal courts.
And my perspective remains that while the executive branch undeniably overstepped its constitutional boundaries, which, we agree on entirely, the core issue is still staring us in the face. The underlying debate over election integrity and the push for verifiable citizenship via the Legislative Save Act is a crucial, unresolved issue for American public trust.
You see it as a necessary evolution.
Right. The executive order was the wrong vehicle, but the necessity of proving citizenship to participate in our democracy remains a vital, unaddressed policy goal.
It is a profound tension that will undoubtedly continue to evolve as state, congressional, and executive powers navigate the boundaries of election law. We leave you, the listener, to weigh these perspectives. You have to decide how to balance the demands of absolute, verifiable security against the mechanical reality of administrative barriers.
Exactly.
Requiring documentary proof of citizenship is like changing the locks on a massive apartment building and telling everyone they need to bring their original deed to get a new key. Yes, you keep out the hypothetical trespasser, but you also lock out the grandmother on the 5th floor who hasn't needed to look at her deed in 40 years. Are we building a system that protects the democratic assets inside, or are we building a fortress that locks the rightful owners out in the cold? If you found this episode valuable, please like, subscribe, share, follow, and turn on notifications. It helps us continue bringing you content like this and ensures you never miss future releases.